Well, I wonder if I could begin by endeavouring to answer a question posed to me by Burrows in relation to the appointment of elders and ministerial servants. We don't think there was any actual evidence before the trial as to Sewell's specific appointment, what the processes were for him being a ministerial servant and then an elder. But there is in the key documents bundle under the statement of facts and issued a summary of the process, which perhaps I could take the court briefly to. It's at page 4, under the heading Ministerial Servants and Elders, and particularly paragraph 12, which reads, "A body of elders made up of mature spiritual men is carefully selected and approved for appointment based on scriptural qualification. An elder would have been baptised for many years and would have served as a ministerial servant." I think he became an elder, Mr. Sewell, about 9 months before the rape.
And I'm sorry to interrupt, but this body of elders is carefully selected and approved by whom?
The process, I think during the period, they were recommended by the body of elders in consultation with the circuit overseer. The appointment required the approval of the Britain branch. That's, I'm told, an ecclesiastical body.
So the body of elders, is that does that refer to members of a particular congregation?
I think so, Lord. The position is that I hope that I can get some absolutely emphatic clarity from that by the end of the case, which is why I'm referring to what's in the statement of facts and issues. I'm going to take some formal instructions to that. That's what I understand the position to be.
Yes, it was something when I was preparing for this case I wasn't clear about. I mean, who are the body of elders? Are they people simply from the individual congregation, or are they a body involving more than one congregation?
I think, subject to correction, which I will provide to the court, they're initially from the local congregation, the Barry congregation, and then in consultation with the circuit overseer, and then it's approval of the Britain branch is required.
And they make the recommendation to the Britain branch, which is
an ecclesiastical body, I've been described to me.
Which is a single body for the whole of Britain, based in London.
Yes.
And is it that body that then, is it the Britain branch which then makes the appointment?
In effect, it has to have the approval of the Britain branch, but it's probably made by the local body.
All right.
I think subject to correction, and I will make sure that the court's got as full a detail as possible. I don't think it's as it were, controversial in terms of the outcome of the case.
No.
But clearly
the local body can't make the appointment without the approval of the branch.
No, that I understand his position.
So it's a veto, in effect.
Yes.
And the congregation is simply the individuals who worship in a particular church, is it?
Yes, and I think if we see from paragraph 18, there were 130 to 160 persons who attended the congregation. 17 men were elders, 20 men were ministerial servants. Most were, or if not all, were married and had children.
But who are the trustees? As I understand it, the appellants are the trustees of Barry congregation. Is that not right?
Well,
is it the whole congregation?
They are an unincorporated association, I'm told. I think it was a charity, and it's now become an unincorporated association. As your Lordship may appreciate, I'm a little hesitant about answering these questions, and I want to make sure that I've got it absolutely right, but those are my instructions.
Okay.
Yeah.
Yes.
And what does, I mean, are the... Obviously, we need to know what the relationship is between the appellants, between the appellants and the tortfeasor. Are the trustees members of a congregation who are entrusted with the bank account or the savings or what?
Yes.
or are they the people in whom the title to the
more like
the church property is held?
I'm not entirely sure of that. The first two paragraphs of the judgment of Lady Justice Nicola Davis do to some extent deal with that. This is at page 88. The judge found that the first and second defendants, the Watchtower Bible and the Tract Society of Pennsylvania Trustees, were vicariously liable. And then she says at paragraph 2, the first defendant is the worldwide governing body of Jehovah's Witnesses. It was unnecessary for the judge to consider the relationship between the first and the second defendants, as the first defendant accepted he would satisfy any judgment against the second. So there wasn't a detailed finding, as it were, on the precise hierarchy.
Is the first defendant in the action simply because it's a body that will satisfy a judgment?
I think it's simply a defendant who was named, as it were, as the defendant once it was clear that there would be no problem, as it were, in someone saying you've sued the wrong person.
Yeah. And who's supposed to be the employer or quasi-employer?
Well, of course, that's one of the issues before the court. But
who does the claimant allege is the employer or quasi-employer?
Well, I think the claimant suggests that the congregation, which is a branch of Jehovah's Witnesses, was effectively the quasi-employer. No doubt the learned friend may clarify if I've misunderstood it, but I think that's the basis of the claim. And it is therefore said that since the congregation, presumably through its elders, will appoint an elder, and then subject to the veto that my Lord Stevens pointed out, they are liable, and my instructions are that the appellants, as it were, accept that if there is a finding against whoever the appropriate person is, the congregation, then they will satisfy any judgment.
So can I just be clear? I realise you want to try and get chapter and verse on this, but which I personally would find very helpful. But your understanding is that the quasi-employer is not the trustees, but the whole congregation. Congregation being a legal entity?
Well, an unincorporated association in its loosest sense, I think you'd call it.
All right, but you wouldn't normally sue an unincorporated association. You'd always sue the trustees, wouldn't you,
yes,
of the unincorporated association?
Or persons
Which is what they've done.
Unless you...
Yes, that may be, as my Lord Stevens says, maybe representing the maybe representing the congregation as an appropriate person to bear responsibility, as it were, in law, if there are to be a judgment. Right,
but then, sorry, I can just finish and then I'll be quiet. But and then the worldwide governing body of the Jehovah's Witnesses, we just put to one side.
I think so.
For all purposes, do we? Thank you.
I mean, it explains the way Jehovah's Witnesses work, but I don't think it's relevant for the purposes of deciding who is appropriate.
So, the trustees effectively representative members.
Yes.
So we have to approach the case on the basis that what's alleged is vicarious liability on the part of all the individuals who happen to worship in this church.
Yes.
But not quite insofar as the Britain branch, which is part of the worldwide organisation, isn't it?
Yes.
Actually approves the appointment of the elder.
Yes, I think...
So to say the quasi-employer is just the congregation, I mean, it appears to me that it wasn't really an issue, and everyone has gone over it and left it to one side, and we're now getting down to the details before this court as to the precise mechanics of it all. Whereas your clients were perfectly content to indemnify the congregation.
That is entirely the position.
Yeah.
And that's probably why I'm floundering, but in attempting to answer the Lordship's questions.
Yes, I think nevertheless, if this court is to make rulings on the boundaries of vicarious liability, we better know the basis on which each of the parties has been content to agree that the arrangement is that the former defendant, the non-appellant defendant, is indemnifying the congregation.
Right, so my Lord, and I will endeavour to give a definitive answer to those questions.
It would also, I think, help me to know not just who appoints elders, but who can remove them. I understand there's a judiciary committee which hears allegations against, I think, not just elders but members of the congregation. But I'm not quite sure who, as it were, wields the and I can't remember the word, but the disfellowship stick, as it were.
Yes.
Well, there's a removal from eldership as one measure, and disfellowship as the equivalent of excommunication.
Yes, it's really who removes them from the status of being elder, I think, that would be helpful. Because that's, on the face of it, the body or persons who have the sanction likely to ensure their good conduct while an elder.
Yes.
And you could widen that even to say whether the worldwide organisation has the ability to remove a congregation.
As a whole?
As a whole, yes.
Yes, I'm afraid I do know the answer to that, but I'll endeavour to try and come up with the answer. And obviously I'll make sure that my learned friend has advance notice of what we're going to say so we can deal with it if necessary.
In essence, it's who has the control.
Control, I can see.
And obviously, stage one depends on establishing a certain kind of relationship between the tortfeasor and some other entity. And it's for the claimant to decide what her case is in that regard and to prove it.
Well, that was indeed the way I think the case was put. I mean, there wasn't any issue about the wrong defendant as it had been taken, but nonetheless, the onus is on the claimant to establish there is a body who has sufficient control to be properly classified as a quasi-employer, so as to surmount the hurdle of stage one. So that's the position. And our case always was that there was no, whatever the correct defendant, whatever the structure of the of Jehovah's Witnesses, generally a congregation or whatever, there was no quasi-employment relationship. I wonder if I might make one or two very brief comments about Jehovah's Witnesses generally. I should say that some of the comments that the judge at first instance and in the case of A and the Court of Appeal have caused quite a lot of disquiet amongst my clients. Let me make it clear that they absolutely abhor what happened to BXB. It's wholly and directly at odds with their beliefs and practices, and she deserves the utmost sympathy, just as Mark Sewell deserves opprobrium for what he did, and of course he was punished. And also there is a considerable history of antipathy towards Jehovah's Witnesses, as we point out in our printed case, and some of it's been noted and disapproved of by judgments of the European Court of Human Rights. Being a Jehovah's Witness does not negate the exercise of free will and does not involve some sort of mind control, as is sometimes suggested. In other words, we live in a pluralist society where we tolerate, in the proper sense of that word, all sorts of religious beliefs, Christian, Jewish, Muslim, to name only the main ones. And there are many subdivisions of these faiths, and all have different practices in terms of rituals, sacred days, clothing, fasting, etc. And individuals may have a greater and lesser intensity of faith. But some of the generalizations about Jehovah's Witnesses are, we submit, verging on the unfair. The statement of facts and issues, subject to the point that's just been raised, contains what I think is necessary for the court to decide. We accept that courts will, from time to time, have to make findings of fact about religious matters, but we submit they should be very careful not to go beyond what is necessary for the resolution of the dispute before them. In this case, the claimant gave evidence before the court and clearly and wholly understandably was very disillusioned with Jehovah's Witnesses generally as a young woman who joined and then in the circumstances that occurred, and she described her relationship with elders and with this particular elder. But of course, and that seems to have been relied on to some extent by the courts below, but of course it is an objective analysis of what the relationship was between whatever the body is and the elder, rather than the individual's claimant's perception of what this particular elder, who was, of course, a tortfeasor and not characteristic of what one would expect of an elder to be.
Can I mention a point just while it's in my mind, so it's not forgotten? There are unincorporated associations such as golf clubs,
Yes.
which have a list of members. Here we're told that at the relevant time, between 130 and 160 persons attended the services of a Barry congregation. Now, you may not answer this immediately, but I'm wondering, is there any analogy with a golf club? Or if I went along to a service once, would I count amongst those 130, 160 people? In other words, is it possible to identify the individuals who are said to be the employers, or not?
Yes, I entirely accept the validity of your lordship's question, if I may say so. I mean, are they people who attend the service once and decide they don't like it and go away, or are they regular? I understood it was probably supposed to convey this was an average congregation of those who attended that particular Kingdom Hall, but I will clarify that matter. Well, then in the quarter of an hour that I have available to me, I want, if I may, just simply to highlight a few of the points in our printed case, not to read them out, of course, but just to highlight them in view of some of the questions that I've been asked. Might I ask the court to look at our printed case, and page 28, I think, is the right number, all the continuous numbering. Paragraph 49, which is at 29, we refer to what Lord Justice Mayers, in fact, said, which is also referred to in the Statements of Facts and Issues, that the rape didn't actually occur whilst Sewell was performing any religious duty. And as the court said, his status as an elder had somewhat faded into the background. It didn't involve child grooming. There was no kind of acquiescence because he was an elder. The relationship began and developed in large because, at any rate, until 1989, the two couples got on well. And then we refer at paragraph 50 to the Statements of Facts and Issues, the fact that they were attending religious services since 1984, made lots of friends, developed a relationship, became very close friends. They went on holiday together, went to houses for tea, and Mrs. B developed a special friendship with Sewell. They were very much the same age, and she regarded him as her best friend. In fact, she was polite about him in terms of how he was originally. Paragraph 53, under the heading of misapplication of the Stage 1 test, we refer to the fact that there was an inadequacy of the inquiry to this extent in the lower courts. And this is the point I was endeavouring to make about what particular perception, a religious perception that an adherent might have, is not, as it were, determinative necessarily of what the proper analysis of a relationship between the tortfeasor and the defendant ought to be. And we borrow from the point about the reasonable observer and representative capacity point. Paragraph 61, we are concerned with the fact that there seems to have been some slight exaggeration of the hierarchy, in that Mr. Schofield gave evidence, and this was noted and accepted, that all adherents, including elders, are equals. This is not the position of some churches where there is a much more formal hierarchy, and they're not required, we quote this, to give unquestioned obedience to elders. Members of the congregation are required to apply their own Bible-trained conscience for simply obeying the instruction or guidance of an elder. We say at paragraph 66 that the overriding characteristics of a relationship that's akin to employment are economic dependence and, to a lesser extent, control, borrowing from Barclays Bank. And at paragraph 68, we say there was no evidence of the Barry congregation exercising any control or the direction of what Sewell should do in his part-time, and it is, of course, a part-time volunteer role as an elder. And we deal with the number of people that were at the congregation who were elders and who were ministerial servants at 69. And then at paragraph 71, we refer to what the primary role of the elders is, which is to take the lead in religious services. 3 weekly public religious services, There were 17 elders in the Barry congregation, and he would only occasionally, therefore, have had a share in conducting the service. They provide comfort and support, but this is done at an adherent's request. There was no evidence before the court that he provided pastoral assistance to anyone, and anyway, it would always be in company with another adult, and there was no permitted exception to this. And we do add this point that married adherents are specifically cautioned against associating alone or developing close friendships with a member of the opposite sex to whom she is not related or married, never any requirement to act as a confidant. So, paragraph 72, so no mutuality of obligation between Sewell and the Barry congregation. Further confirmation that the relationship not akin to employment, not paid, participate at their own expense, don't have to make any pledge or promise of obedience, not provided with special garb, free to decide whether or not to perform any religious activity, and free to stop. Can I take
is it your submission that there are no circumstances in which an elder, the activities of an elder, could be regarded as akin to employment for the purpose of vicarious liability?
Yes.
No circumstances whatever, no.
So, if we posit a complete change of facts, where an elder is conducting a Bible class and orders somebody from the congregation to go to a private room and then sexually assaults them, you say, well, it's not akin to employment, so that's the end of it.
My answer sounds unsympathetic, but as a matter of law, we say that one has to look at what the elder's position is vis-à-vis the defendant, and whether or not he is out proselytising or at a home may be relevant, but our submission is, we don't need to go this far, of course, on the facts, but we say that an elder is a member of the congregation, albeit with higher status than a ministerial servant, but is not in a position like a priest or someone working full-time in a school who would be in a position, notwithstanding the unusual financial arrangements, that they're akin to employment.
Yeah. Well, that's what I understood the submission to be, because if you're saying there's no satisfaction of stage one, I think you have to say, do you not, that what you're really founding on, to get rid of these difficult examples, what it might be said, is stage two. But as the way you've put it, you really have to say that there are no circumstances. And if we take just less controversial situations in one sense, because they're not involving intentional torts, let's say we have an elder who's setting up the service in the Kingdom Hall and is carrying chairs, the chairs topple over and they injure somebody. You would have to say no vicarious liability there, I think.
Of course, every individual, whether they're driving a car or whether they are moving furniture around, would owe a duty of care to another individual. It's a matter of kind of Donahue and Stevenson type analysis.
No, but the question is
vicarious liability.
Whether the congregation will be vicariously liable.
No. We submit not.
No. I mean, the first example put to you, the Bible class example, introduces a fact scenario which may be materially different. If a congregation instruct an elder with a specific task which involves, in the case of a Bible class, probably contact with young people over whom he's in a position of authority, then that scenario may lead to a different answer from a case like the present, where those attributes don't appear to be present.
Of course, I mean, our primary submission is that an elder would never be responsible, but there would never be vicarious liability. But if there are different factual scenarios, and I'm wrong with this central submission, then one does need to look at the facts as to whether there has been particular responsibility given to an elder outside and above and beyond perhaps what is the normal role that an elder should perform. And I suppose it is possible in those circumstances the court might be persuaded that in this particular context the relationship was more akin to employment. But I nevertheless submit that the relationship generally of an elder would not be regarded as akin to employment, or should not be regarded as akin to employment, and that therefore the claimants don't get past stage 1, but of course, even if I'm wrong on that, there is the stage 2 question, which we submit. There are strong reasons for suggesting the claimants cannot surmount that test either.
Suggesting that it would ever occur, but if one of the roles is to conduct religious services, and if there was harassment during the course of that service, would that be akin to employment?
I suppose, I don't think it would be, with respect to law, akin to employment, because...
No, I was just saying that if the role is to conduct a religious service, and that role has been delegated to the elder, which I understand you to accept.
It's true that elders do from time to time have that role, yes.
Yeah. Well, they're obliged to take it on.
Yes.
Yeah. And if they had, during the course of a religious service, would they be in a role akin to employment during the course of conducting that aspect of their work?
We submit not, because there aren't the indicia of employment, where, however, it might be the case, well, if I'm wrong on that, obviously conducting a church service would be much more closely connected with the quasi-employment if I was wrong on that.
Well,
than this.
It's just perhaps easier to analyse the case on the closeness of the connection.
Yes.
Particularly in view of the fact that we haven't really got much of the detail about how it was. Well, it seems to have been accepted that the worldwide organisation would stand in the shoes of the congregation, and so a lot of the evidence perhaps wasn't heard properly.
That's true, I would, I think, yes.
Because we don't have the answers to various questions we posed.
I'm afraid I apologise for that, but I suppose sometimes in litigation,
I know.
where there is an issue that nobody's taking at the time, then insufficient exploration has been probably on all sides in this case.
But stage 1 was a live issue, wasn't it?
Oh, stage 1 was a live issue. Both stages were both live issues.
I didn't see how stage 1 could have been decided without deciding who is it whose relationship with Sewell is relevant, and once you've decided that question, what was the nature of that relationship?
Yes, I have to say that in the Catholic welfare case, we went into a great deal more of the evidence of that. And that
You can see the court wrestling with it over pages of judgment.
No, indeed, I remember the submissions only too well. It was a complex setup. In this case, I think that it wasn't an issue, so it hadn't been explored as thoroughly as it might have been. And also, I'm conscious of the time, and
Yes, unfortunately, the time you indented for has been almost entirely taken up reminding us of the leading cases.
It was, and I think that
in a nutshell, your case on stage 2.
in our case on stage 2, I think I can deal with very briefly. It's at page 41.
Can you give me a paragraph?
A paragraph applying the test. We say it's not. Paragraph 96. The Court of Appeal failed to consider there was a common denominator in all cases of the case of sexual abuse where the close connection was found to be satisfied. It took place in an institutional context. That's where we say there's a difference. And none of the indicia apply in the present case, 97. A married adult woman who had her own home and family. The Barry congregation did not have physical care or control over her, nor did it require Sewell to develop an emotional bond with her. And therefore, at paragraph 108, we say, and I'm now concluding, the stage 2 analysis falls at the first hurdle. It was no part of Sewell's spiritual and religious duties as an elder, and it was not within the authorised field of activities entrusted to him by the Barry congregation to cultivate a friendship with Mrs. B, a married female adherent. It was the close personal friendship with Mrs. B that created the opportunity for him to rape, and it did not occur whilst Sewell, this is paragraph 109, was performing any religious duty. That perhaps is really what I was attempting to say in the answer to the question by Lord Stephen. This wasn't a religious duty as such. Further, the rape occurred in the Sewell's family home in a social context, unlike in JGE, that's the English case, Christian Brothers and Cox. And it occurred when Mrs. B decided to go into the back room of the family home to check on the seal because he'd isolated himself after getting drunk and acting boorishly towards his wife. So, my lords, we submit that this appeal to be allowed on the basis that neither stage 1 nor stage 2 were satisfied.
Could I just ask one question? In paragraph 103, you say the close connection test requires the court to focus on objective causal links. Is the close connection test necessarily one of causation?
So
I thought they're dicta to the contrary, are they not?
Sorry, did your lordship say 103?
Paragraph 103, second last line, final sentence.
Yes, I see. Yes. So I'm not sure that's particularly happily put, actually. The focus on an objective connection between the authorised field of activity and the tort, not the subjective and after the views. In fact, I think causal links is perhaps not a particularly helpful way of putting it.
It didn't seem to be consistent with the authorities.
No.
No, thank you. So objective connection.
I think an objective connection between the close is a better way of putting it, and I'm grateful to my lord for pointing that out.
Thank you.
Yes, Mr. Counsel.
My lords, can I wonder if I could begin by identifying the main features of this case which we say are relevant to each of the two stages. First of all, stage 1, the elders are at the heart of the congregation because they lead it. They exercise jurisdiction over all aspects of the lives of the congregation members, otherwise known as publishers. They are expected to follow strict rules, from those relating to serious sin to what others in different organisations might regard as normal activities, such as smoking and drinking, and even the clothes that members of the congregation wear. An elder doesn't leave his role and duties at the Kingdom Hall when he goes home. He's expected to behave at all times in a way which is consistent with his status. Failure to do so can lead, as it did here in fact, to removal as an elder. Their personal interests and private lives must always take second place to the good of the Jehovah's Witnesses organisation. The organisation itself is highly structured, from its governing body in New York to its branch office in London, to districts, at the relevant time at any rate there were districts, circuits and congregations. Elders are required to act as shepherds to the sheep-like ones, the ordinary members of the congregation. Their authority comes from Jehovah. They share the aims of the organisation as a whole, which is to spread the word, and they follow directions from above in carrying out that role. Elders are integrated into the structure of the organisation as a whole. They are appointed and assigned privileges. They lead the organisation's principal purpose, namely spreading the word of Jehovah. Not only is an elder fully integrated, but he's controlled by the religious rules, beliefs, and principles of the Jehovah's Witness organisation, as set out in the Scriptures. Indeed, as has previously been observed, the nature of that relationship is in many ways an even closer relationship than that to be found in an employer-employee relationship. That was the conclusion reached by Mr. Justice Globe in A against Watchtower. In no way can it be suggested, and it hasn't been, that elders carry on the business of the organisation on their own account. The essence of the stage 1 test, as it applies here, is that which your Lordship, my Lord Reed, set out in Cox and Ministry of Justice. Namely, the court should focus on the risk created by the role assigned to the tortfeasor. In this case, the judge and the Court of Appeal applied that test. There can be no question, we submit, but that the judge and the Court of Appeal were right to do so on the facts found by the judge. And the same is the case, we submit, with Stage 2. The present case bears close similarities to the case of Marga. I'll take you to that case, if I may, in a little while. I think it was just about the only authority which Melanie Friend didn't take you to in detail. The priest, that's the case of the priest who abused a boy who was not a member of his congregation. In that case, the progressive stages of intimacy were possible only because of the priestly status and authority conferred on the abuser over the claimant. So here, all contact between the respondent and Mr. Sewell ultimately stemmed from his role, first as a ministerial servant and then as an elder. As the judge found, the rape would not have been committed but for the fact that he was an elder. Members of the congregation are taught to be obedient and submissive to elders whose authority comes from Jehovah, to the extent that he, Jehovah, would be displeased if members did not follow the elders' instructions. Mr. Sewell's manipulative and bullying behaviour was enabled by his status as an elder. It was his status that enabled him to, first of all, to kiss BXB and other women on the lips when he greeted them at the Kingdom Hall, and then to progress to increasingly intrusive, unwanted intimacies with BXB, leading, of course, ultimately and finally to the rape. The rape itself occurred after the two couples had been out pioneering and had just returned. But an elder, of course, performs the role of elder at all times. Mark Sewell had not, to use an expression which I'll come back to in the case of Morrison's, the first Morrison's case, metaphorically taken off his uniform when the four had returned to the Sewell's house. So, putting all of those two together, because as your lordships will know, this is a case where the synthesis of the two stages is so important. Whilst at stage one, the key, we would say, is the risk created by the role assigned to the tortfeasor. At stage two, the court needs to consider the extent to which there is a close connection as between the stage one role, including the risk created, and the tort. And in reality, we would submit, there is nothing in this case that distinguishes the Jehovah's Witnesses organisation from the various other religious organisations which have been held by this court to be vicariously liable for acts of sexual abuse committed by those who have had responsibility and authority bestowed upon them. So, if I may, just a few preliminary observations on the law, save perhaps on the issue of what is meant by the expression, the tailored version of the close connection test. The parties do not disagree on the law. Both parties rely on existing legal principles in this appeal. Neither seeks to persuade this court to depart from any of its previous decisions. The most recent judgments, of course, are the second Morrison's case, various claimants against Morrison supermarkets, and the Barclays Bank case, but they were not intended as your Lordship, Lord Reid, said in the second Morrison's case, to result in a change in the law of vicarious liability. The legal test, of course, for the imposition of vicarious liability remains that set out by Lord Phillips in the Christian Brothers case, the two-stage test to which your Lordships have already been taken by my learned friend. And I won't take you to that again. Lord Phillips went on to note that this is paragraph 21 of that case, there is often a synthesis, between those two stages. This is inevitable where at stage 2, the court is examining the extent to which the tortious act is closely connected to the relationship defined at stage 1. And if I may say so, one can see it in your Lordships, my Lord Reid's formulation of the test in Cox. Can I just take your Lordship to page 498 of your bundle? Your Lordships have been referred to.
Just before you do,
yes.
In your introductory remarks just now, did I note you correctly as saying that at the stage 1 test, relevant factor is the risk attached to the role assigned to the tortfeasor?
Yes.
Mm-hmm. That's what right, I see. Just 448, thank you.
Thank you. Page, yes.
Can I just orientate myself around it in relation to the close connection test?
Yes.
What was the function that Mr. Sewell was carrying out that had been entrusted to him by the congregation at the time that this tort was committed?
My Lord, I'll develop this later if I may, but in my submission, that is why the observations of Lord Justice Longmore in Margot is so important, because one needs to look at the progressive stages of intimacy. Those stages began.
Was there any factual finding of grooming?
My Lord?
Was there any factual finding of grooming?
There were factual findings of the kissing on the lips in the Kingdom Hall, leading on to flirting and sexual innuendo, leading on to a request by Mr. Sewell that the two should run away together, and then we would submit to the rape itself.
Go back to my first question. What was the function or field of activity being carried on by Mr. Sewell at the time that this offence was committed?
In my submission, it's the conferral of the authority and status of the elder, which he still had with him.
But he didn't command the poor unfortunate individual to come into the room at all.
No.
So how does the authority impact in this case?
Well, just as in the case of Margot, this was a young boy who was not a member of the congregation, and the priest gradually increased the intimacy with this boy until he was in a position to abuse him.
Was it at a youth club, I think?
He started a youth club,
yeah.
And the boy started to come, and he gave him jobs to do. He cleaned his car and so forth, all sorts of things which had very little connection with the church itself, but which led on to the intimacies and the abuse. May I develop that in due course when I come to stage 2?
You were wanting us to look at page 498.
I was. Top of the page, paragraph 24. Your Lordship says this in Cox. Lord Phillips's analysis in the Christian Brothers case wove together these related ideas so as to develop a modern theory of vicarious liability. The result of this approach is that a relationship other than one of employment is in principle capable of giving rise to vicarious liability, where harm is wrongfully done by an individual who carries on activities as an integral part of the business activities carried on by a defendant and for its benefit. and then leaving out the passage in brackets, and where the commission of the wrongful act is a risk created by the defendant by assigning those activities to the individual in question. In my submission, that feature, the creation of risk by the assignment of roles to the tortfeasor, is, in my submission, critically important, certainly in these kind of cases, if not in all cases. And one sees that time and again in the authorities to which your lordships have been referred this morning. But each stage requires a separate analysis, and the appellant, my learned friend, rightly says that there needs to be a searching inquiry into the detailed features of the relationship of stage one, along with an analysis as to whether there is a close connection between that relationship and the tort, stage two. The difficulty we would submit for the appellant in this case, the appellants in this case, is that both Mr. Justice Chamberlain and the Court of Appeal conducted that very searching and detailed inquiry in respect of both stages of the test and unanimously reached the same conclusions on the facts found by the trial judge, which the appellant cannot, as my learned friend quite rightly accepts, cannot now challenge. The two stages of the test are, we would submit, clearly established. So can I turn to stage one? The requirement for the judge to make objective findings of fact about the Jehovah's Witness organisation and the role of an elder within it. The trial of this claim required the judge to make specific and objective findings both about the way in which the Jehovah's Witness organisation operated generally, and more specifically about the role elders played in the Jehovah's Witnesses organisation. And in order to do that, he needed to rely upon objective findings, because, as Lord Newberger said in the case of Shergill and Carer, which your lordships don't have in the bundle, but there's a reference to it in our written case at paragraph 12a, where a claimant asks the court to enforce private rights and obligations which depend on religious issues, the judge may have to determine such religious issues as are capable of objective ascertainment. In this case, the trial judge had to make an objective ascertainment of the role of an elder if he were to conduct that searching inquiry into the stage one relationship between the Bowie congregation and Mr. Sewell as an elder, and if he was able to decide whether it would be fair, just and reasonable to impose vicarious liability. And we would submit that he did just that. He analysed the evidence of all the witnesses in very great detail in 75 paragraphs of his judgment between paragraphs 32 and 107. And then he set out his conclusions on stage one between paragraphs 157 to 163. And in carrying out that analysis, he relied principally on two sources of evidence. The first was the evidence of the appellant's own witness, Mr. Schofield, about the role Sewell would have played as an elder in its organisation. And the judge accepted Mr. Schofield's evidence in its entirety. And secondly, the contents of the Jehovah's Witnesses' own publications, in particular the Watchtower magazine, but also another magazine called Awake, which Mr. Schofield accepted accurately set out the Jehovah's Witness teachings. That evidence was important because the contents of the Watchtower magazine and other publications amounted to an objective source of information about the organisation and was firmly rooted in the Bible, and so did not change. Mr. Schofield accepted this in cross-examination at page 303 of the core bundle. So that evidence was not vulnerable, as it may be said other evidence is, such as the subjective beliefs of those in the congregation, not vulnerable to the potential vagaries of subjective beliefs or the passage of time. Indeed, one of the Watchtower articles, the most important one, in fact, the one which dealt with the importance of obedience by publishers to elders, was published only a few months before the rape itself, and would have been discussed up and down the country by publishers at the Bible sessions, which were held every week, the weekly study groups, shortly before the rape. The evidence of Mr. Schofield in cross-examination, it's core bundle page 317, to a question from me. So is BXB's description of how this sort of article is dealt with correct? Namely, they discuss it together in the Watchtower study meetings. That may not be the right description of it, the Watchtower study meeting, and when they come to a question, they all answer it together. Yes, said Mr. Schofield, that was an accurate description. So there'll be a conductor of the meeting. There will be one assigned to read the paragraphs. The paragraphs will be read in turn, and then the questions will be asked, and it will be open to discussion for anyone to participate who may wish. The judge's findings and conclusions on stage one, based upon that evidence, are set out succinctly but fully, we say, in his judgment at paragraphs 158 to 164. Can I ask your lordships to turn to page 203 of the core bundle? Where his lordship, Mr. Justice Chamberlain, set out the facts which he found from the evidence that he had heard. First of all, at paragraph 158, the elders are the spiritual leaders of the congregation. They're appointed. To be appointed an elder, a publisher must first have served as a ministerial servant and demonstrated that he's spiritually suitable to be an example to others. An elder may be removed if he fails to maintain the high standards expected of him, whether in performance of his duties as an elder or in his personal life. And just in answer, I hope this helps, to the questions that my learned friend was asked a little while ago about the source of the evidence. Thank you very much. So far as appointment of the elder is concerned, there's some evidence about that at page 386 in your bundle. This is the witness statement which the judge accepted from Mr. Schofield. And at paragraph 35 at the top of the page, this is in the section dealing with elders, Mr. Schofield says, as with ministerial servants, at the relevant time period of this claim, elders were recommended for appointment by the congregation body of elders in consultation with the circuit overseer when he made one of his biannual visits to the congregation. If the circuit overseer agreed with the elder's recommendation, he would complete an S2 form with the elders and submit it to the service department for approval. I think the service department is in London. The service department would then either approve or refuse the appointment. And then so far as removal is concerned...
So it's clear from that when reference is made to body of elders, it means the elders of the particular congregation rather than a supra-congregational selection of elders from different congregations.
I think that's right. Yes. The only circumstances in which other elders are involved with decisions about a particular congregation are in relation to the removal, where a committee is set up.
Situation, yes.
Yeah, there are different, yes, depending upon what it is they're looking at. A judicial committee is very often, if it's dealing with an allegation of misconduct against a particular publisher in a congregation, then elders from that congregation would sit on it. But when it is dealing with elders, then it's slightly different. And if your lordship turns
but just to make sure we see that, so the congregation body of elders makes a recommendation.
Yeah.
It gets the support of the circuit overseer, but it's the London, it's the branch level that make the appointment. That seems to be what
Mr.
Schofield's saying.
Yes. And if you turn to removal, we do have some evidence about that at page 174. Rather, when I say evidence, there is evidence about it, and it's referred to in Mr. Justice Chamberlain's judgment at paragraph, first of all, paragraph 73. He sets out what FXC, who was the father of someone else who was abused by Mr. Sewell, says in that paragraph about the setting up of a judicial committee. And then at paragraph 74, he says CXC's allegation, this is the daughter of FXC, was referred to a special committee consisting of 7 elders, and then he names them. The committee, and you'll see there that some of them come from another congregation reasonably near, and others come from further afield. The committee spent 7 days in Barry interviewing congregation members. On the final day of their visit, the elders gave their judgment at Penarth Kingdom Hall. Tony Sewell was removed as an elder. Tom Brown was removed as presiding overseer. Advice was given to the other individual elders involved. The local elders then formed a judicial committee to deal with both CXC's and Mrs. B's allegations against Mark Sewell. And it was only later that Mr. Sewell, now no longer an elder, was disfellowshipped for drunkenness, apparently. But coming back to, if I may, paragraph 158 of the judge's judgment.
So the power to remove isn't in the congregation, is it? Or will they delegate it to some other?
I don't think it's delegated, presumably by the branch, to a special committee.
Yes, I think that's right. Whether the branch chooses the members of the special committee, I'm afraid I can't give you that answer.
No. I can, if it happens, but that's because I've got the rules in front of me. They're from the Jehovah's Witnesses, but they're not in evidence, so I won't tell you.
Can I take you back then, please, to 158, which is...
I can't help wondering about 157. At the first stage, the question is whether the relationship was capable of giving rise to vicarious liability. The key questions, apparently to adopt my formulation in Cox, are first of all whether Sewell carried on activities as an integral part of the business activities carried on by the defendant for his benefit, and secondly whether the commission of a rape was a risk created by the defendants. I can't myself see how 2 forms part of the stage 1 test at all.
Well, with respect, our submission would be that in these cases, risk is an important aspect. The difficulty is that there's always a synthesis between stage 1 and stage 2.
Well, you say that. I wonder if that's right. Certainly, I wonder if it's right. But I mean, I can see why. I can see at least why people might think that risk is relevant at stage 2. But what's it got to do with whether the relationship is akin to employment?
Well, I think what we would say is it's a feature of the relationship between, in this case, the elder and the defendant, that in the appointment of an elder, you are creating or you are enhancing the risk, in this case, of sexual abuse.
One of the policy reasons which for vicarious liability was the activity, was part of the business activity of the defendant. That is, the activity of the wrongdoer was part of the activity of the defendant. And to my mind, that sits more easily with the close connection test rather than with whether or not stage 1 test.
Yes. Yeah. Well,
when you say there's a synthesis, I was just wondering why this overlapping might confuse as to the application of the two tests.
It is certainly capable of confusion, but in my submission, one of the features in these cases, particularly in cases of sexual abuse, in my submission, is that the defendant is bestowing authority upon somebody, and in thereby creating a risk, which is part of that which connects it to the tort at stage 2.
Yes, but if the question at stage 1 is whether the relationship is akin to employment, you can leave to stage 2 the second question, I'd have thought. You have, I think, a respectable source of the synthesis concept in, I think, Lord Phillips himself.
Yes.
Yes, but I must say, when I read his judgment, I wondered what the synthesis was. I mean, a combination of components to form a connected whole. I'm not sure it tells me very much. Because there are clearly two stages to be addressed.
Yes.
And I'm not sure synthesizing them in any way will assist us.
So be it. Let me come back to that, if I may, when we deal with stage 2.
Risk was mentioned by Lord Phillips as one of his 5 factors, and I think that was the context which I referred to it in Cox. But in paragraph 35 of Christian Brothers, he's explaining what he sees as the policy reasons for imposing vicarious liability at all. So he's looking at the entirety of the concept rather than analysing it into a stage 1 and a stage 2.
Yes.
The problem is, if you answer question in paragraph 157, the answer to the small question 2, yes, there's not a lot of room left to answer no later on. Yeah. It's stage 2.
Quite.
Well, yeah, the risk has to be of the actual tort which has been committed. So if, for example, I'm taking things slightly out of turn, but if you
I'm sorry just to butt in, but if you go to page 497, paragraph 23, about halfway through it, where the President considers the third factor, it doesn't really tell you very much about, well, it doesn't require you to identify that it was rape that was the risk. It's saying, well, if you create a situation, there is a risk of individual behaving negligently or indeed committing an intentional wrong. It's a fact of life. Anyone who employs others to carry out activities is likely to create the risk of their behaving tortiously within the field of activities.
Unless what's meant there is that the risk which is being created is the risk of this specific tort. I mean, take for example, if I may, a cashier at a supermarket who
not such that you have to identify a specific tort. I think you have to identify that you've created a risk.
The risk of the tort.
Well, that's the close connection stage of it.
Yeah,
That's that you deal with that at the second stage.
yes.
I'm just wondering whether these factors in the synthesis really helps at this stage, at the first stage.
Well, Mallows, can I put that to one side and move on just for now and come back to this when dealing with stage 2? I'd got, I think, to part of paragraph 158 on page 203 in the judgment, dealing with the facts which the judge found. An elder must demonstrate that he's spiritually suitable to be an example to others, may be removed if he fails to maintain the high standard expected of him. And then again, they are the principal conduit through which the teachings of the faith are disseminated to the congregation. Insofar as the congregation of Jehovah's Witness acts as a body, it acts through its elders. An elder is integral to the business of the congregation of Jehovah's Witnesses, as a priest is to the business of the Catholic Church. And then skipping on a little, if I may, to paragraph 161, His Lordship says, first, any organisation that confers on its leaders powers and authority over others creates a risk that those leaders will abuse that power and authority. This is as true of a religious organisation as it is of a secular one. There's no doubt that the teachings confer on elders considerable power and authority over other publishers who are enjoined to be obedient and submissive to them, at least when their guidance doesn't conflict with the Bible. Can I just remind your lordships of one other passage which Mr. Justice Chamberlain sets out in his judgment. If you would go back to page 182, paragraph 105, Mr. Justice Chamberlain set out a number of extracts from the Watchtower article, Be Obedient to Those Taking the Lead. And I won't read them all out, but can I just take you to the one at number 13, the little number 13, on the following page, page 183, where there's a passage in that Watchtower article. In the world, there's a tendency to reject leadership. As one lecturer said, the rising education level has improved the talent pool such that followers have become so critical they're almost impossible to lead. But a spirit of independent thinking does not prevail in God's organisation. And we have sound reasons for confidence in the men taking the lead among us. Those are, of course, the elders. And missing out the quotation from Timothy goes on, they're trained to be kind, loving and helpful, yet firm in upholding Jehovah's righteous standards. The elders adhere to scriptural truth, holding firmly to the faithful word, that they may be able to exhort by healthful teaching. And then, last sentence, instead of feeling frustrated by their limitations and treating their counsel lightly, let us appreciate and accept the Bible-based direction of the elders as coming from God. So, whilst it's said quite rightly, it was never disputed, that a publisher should not unquestioningly obey every direction from an elder if that direction was not based upon scriptures or was contrary to scriptures. What this Watchtower article is saying is that you should appreciate and accept the Bible-based direction of the elders as coming from God. And going back, if I may, to His Lordship, Mr. Justice Chamberlain's judgment, he says this at paragraph 162, where an organisation makes rules for all aspects of its adherents' lives and sets its leaders up as moral and spiritual exemplars, it imbues those leaders with power and authority even outside the confines of their religious activities. The suggestion that publishers should reject instructions from elders that do not accord with biblical teaching must be seen in the light of the specific guidance that the spirit of independent thinking does not prevail in God's organisation, and we have sound reasons for confidence in the men taking the lead among us. That elders adhere to scriptural truth, we shouldn't magnify elders' human imperfections. An organisation that chooses to give advice of that kind creates a risk that its adherents will mistakenly follow the instructions they're given by elders, even if, on a proper analysis, they're contrary to the biblical teaching. And then he goes on to deal with the abuse of power that sexual abuse is in that paragraph which follows on. What we would say about that is that doesn't leave much room for the publishers to exercise their own judgment, given the teachings and the authority, the teachings as set out in the Watchtower magazine. BXB's evidence was accepted by the judge at paragraph 56. So if your lordships would turn back to page 170 in the judgment, where Mr. Justice Chamberlain says it was suggested to Mrs. B that there was no scriptural requirement to befriend or to give unquestioning loyalty to ministerial servants or elders. Mrs. B's answers on this were clear. Jehovah's Witnesses were taught that they should maintain good association, and ministerial servants and elders were regarded as morally virtuous. Jehovah's Witnesses believed that they were appointed by Jehovah, so by obeying them, one was obeying Jehovah. And then she goes on to say that she'd known cases where those who questioned elders had been labelled as insane or apostates. Applying the reasoning of Lord Justice Longmore in Margot, to which I will come back if I may, the imposition of power to the elders by the appellants further creates the risk that they will abuse it. Can I just deal with 3 points made by the appellant in its written submissions on the evidence at stage 1? First, briefly, it's simply wrong to suggest that the trial judge simply adopted the judgment of Mr. Justice Globe in A against Watchtower Bible and Tract Society. The findings of Mr. Justice Globe were consistent with the evidence that Mr. Justice Chamberlain heard about the role of elders in the organisation. And as is evident from Mr. Justice Chamberlain's judgment, his analysis was careful and considered. Indeed, at paragraph 159, he specifically made clear that he was aware that Mr. Justice Globe's conclusions were based on evidence before him, but he says the evidence that he had heard was the same. The appellant's case makes sweeping criticisms of the nature of both the trial judges and the Court of Appeal's inquiry into Mr. Sewell's role within the defendants' organisations. First, it said that the trial judge only considered the role of elders generally, not Mr. Sewell's individual role with the Jehovah's Witnesses. That, with respect to his misconceived argument, even if, strictly speaking, the test required an analysis of Mr. Sewell's role, he had been appointed as an elder, and it was his role as an elder within the Jehovah's Witnesses which needed to be the focus of the analysis. It wasn't suggested that he had adopted a role which was different from that performed by elders generally, as Lady Justice Nicola Davis put it in the Court of Appeal at paragraph 79 on page 136 in the bundle. It was the defendants who chose to call Mr. Schofield to give evidence. If it was any part of the defendant's case that Mark Sewell had not had conferred upon him the authority and duties of an elder, that point could and should have been taken at trial, but was not. It's absolutely clear that the trial judge analysed Mr. Sewell's role as an elder within the congregation, and he did so, as I've said, from the evidence of Mr. Schofield and from the various publications, together with other evidence where relevant and consistent. And thirdly and lastly, there was also evidence from a former Jehovah's Witness who was called on the respondent's behalf, FXC, and who is wholly unjustifiably, we would say, described in the appellant's case as a disgruntled former adherent. That's page 50 in the core bundle in the appellant's case. That label wasn't accepted by the trial judge. Indeed, the judge at paragraph 78 on page 175 in the bundle said the opposite. He said the careful and balanced answers he, that's FXC, gave in cross-examination increased my confidence in the reliability of his evidence as a whole. So it's quite wrong, and in my submission unfair, to describe FXC as a disgruntled former adherent, as if in some way that coloured his evidence. To suggest that the trial judge relied upon FXC's evidence, or indeed even BXB's evidence, to reach, to use their words, sweeping conclusions about an entire religious community is, with the greatest of respect, an extraordinary assertion. Quite the opposite, in fact. He used the sources of information most likely to be capable of objective assessment, namely Mr. Schofield and the articles, supported by relevant other evidence, to reach factual findings which are unimpeachable. In reality, we would say, the appellant's real complaint in this case is about the objective factual findings made about Mr. Sewell's role as an elder by the trial judge, which the appellant doesn't like. They are described as surprising conclusions or subjective perceptions of others about that relationship, when in reality there's no basis for those criticisms. The central question, of course, before this court is whether the trial judge and then the Court of Appeal misapplied stage one, given the facts which the trial judge had found. And those findings were rightly upheld, we would say, by the Court of Appeal in paragraphs 69 to 81 of the judgment of Lady Justice Nicola Davis. It's page 134 in your bundle.
Page
134.
Thank you.
At paragraph 75, sorry, I haven't given you that page reference, it's wrong. Page 135, my apologies, is the passage I want to refer to, where Her Ladyship says at paragraph 75, the judge did carry out a searching inquiry as to the role of elders within the Jehovah's Witnesses organisation. The judge's findings are clear, cogent, and reflect the evidence. And then she sets out in a list the core findings which the judge made. Those are the ones to which I've taken your lordships already. And at paragraph 76, she makes the observation to which I've taken you already, I think, about the comparison between this case and the judgment of Mr. Justice Globe in the case of A. At 77, I accept that the judge's finding as an elder is as integral to the business of the congregation of Jehovah's Witnesses as a priest is to the business of the Catholic Church. It's based on the evidence before the court and was a reasonable conclusion to draw on the facts. At paragraph 78, as to the question of whether the commission of the rape was a risk created by the Barry congregation in assigning the activities of an elder to Sewell, she referred with approval to the findings set out in the paragraph to which I've already referred you, and she then sets out again those paragraphs. And then at 79, she rejected the contention that there was no evidence of the actual religious activity of Mr. Sewell, making the point that I've already taken to, that it was the appellants who chose to call him. And then at paragraph 80, she concluded that the findings of fact made by the judge were based upon that evidence, or were inferences which could reasonably be drawn from it and from articles in the Watchtower magazine. Lord Justice Mayles and Lord Justice Bean agreed with the judgment of Lady Justice Nicola Davis on stage 1, but didn't deal with the question of stage 1 specifically in their judgments. So applying all of that to this case, the courts below identified and applied the law correctly, we would say, in determining that stage 1 was satisfied. Your lordships have been taken to the authorities, so I can take this, I hope, quite shortly. In E, the judgment of Lord Justice Ward, Lord Justice Ward sets out 5 signposts, different, of course, from the 5 policy reasons given by Lord Phillips, save for the number of them. And can I take your lordships to that judgment of Lord Justice Reed at page 572? I think your lordships were taken briefly to this. Paragraph 72 of the judgment refers to an article by Professor Kidner where he suggests 5, I think they're referred to sometimes as signposts. First of all, control by the employer of the employee. Secondly, control by the contractor of himself. Often those two issues are dealt with together. Thirdly, the organisation test in this first sense of how central the activity is to the enterprise. Fourthly, the integration test in the sense of whether the activity is integrated into the organisational structure of the enterprise. And fifthly, is the person in business on his own account, the entrepreneur test, not really a separate test as it's intimately involved in the other 4, but it needs to be highlighted so that the burden of proof is right. And any application we would submit of those signposts, in this case, strongly point towards a relationship akin to employment, where, first of all, dealing with control, and if I may, can I deal with signposts 1 and 2 together, so controlled by the employer, by the appellants, and controlled by the contractor, by Sewell of himself. The Jehovah's Witnesses continue to exercise a high degree of control over the role of any elder, much more, we would submit, much more control than an ordinary employee. The organisation appoints the elder and has the power to remove him from office, as we know happened to Mr. Sewell in this case, and indeed another elder and the circuit overseer. Almost every aspect of an elder's day-to-day life, along with that of all members of the congregation, is controlled by the organisation. As the court heard from the witnesses, being a member of the Jehovah's Witness organisation is a way of life affecting every aspect of their lives.
I mean, that's probably true of all members of the congregation, isn't it?
It absolutely is, yes.
But it didn't strike me that it was necessarily right to say that only affected elders.
No, it doesn't. That's absolutely right. It applies to every member of the congregation. And in a sense, it's relevant perhaps also to the integration test as much as the control test. As your lordship rightly says, it affects all of those in the congregation. They're encouraged to associate only, or at least mainly, with their own.
Was that put in evidence? I mean, it's something which one occasionally hears, but I'm not sure I picked it up from the evidence.
Well, yes, I think it is. I may have to.
Don't worry now, but if you have a reference to that, I'd be grateful.
I'm fairly sure it is. I think quite carefully went through to check that they were, and we'll pick that up and come back on that. If just by way of example, if a wife or husband leaves the congregation, then all others, including the spouse, are expected to shun them. That's the word that they use. As happened here, sadly, because BXB happened to BXB, after all of this, she decided, perhaps for understandable reasons, to leave that congregation, and she was shunned by all members of the congregation and indeed by her husband. Other examples of which I can give your lordship the reference. For women, full-time work is discouraged, though it's not forbidden, and there's a reference to that at page 163 in the bundle. Elders tell publishers what to wear, what films to watch, and what music to listen to. That's page 175 in the evidence which was accepted of FXC. And indeed, elders advise publishers where to work. Again, FXC's evidence, which was accepted, was that I think he was a window cleaner, and he was specifically told that he should not work. He was an elder as well, should not work at army bases. He shouldn't clean windows in army bases for reasons derived from the Jehovah's Witnesses' beliefs. As I've said already, they're at the heart of the congregation. They lead it. As shepherds, they're looked up to with respect. They enforce a strict moral code covering everything publishers do, and they do so in two ways. We've heard about judicial committees, but a slightly less formal way was the practice of calling out perceived inappropriate behaviour by a shepherding call and a conversation between an elder and a member of the congregation. Unlike an employee of a business or a person in a position of perhaps responsibility in a church congregation, the elder doesn't leave his role and duties in the Kingdom Hall when he goes home. He is expected to behave in a way which is consistent with his status and the respect accorded to him in everything he does, and to demonstrate the highest degree of propriety and rectitude. He's more likely, perhaps because of his status as an elder, to be the subject of scrutiny by others because of his position. He's enjoined to act as an exemplar of the life which Jehovah's Witnesses are expected to lead according to the Scriptures. At no point, as I've said already, does he take off his metaphorical uniform and go home to a different life, as of course employees very often would. Failure to lead with...
Does it follow from that that there's almost no activity or tort that this individual elder might commit that isn't going to tie in the congregation for vicarious liability?
Well, it's perhaps I'll come back to that at stage 2, but I do say that one does need to identify the specific type of tort which has created the risk. If it's a tort which by reason of his appointment as an elder, you're not increasing the risk. If, just to take an example, perhaps it was an assault rather than sexual abuse or theft, then that might not be the case. But you do need to identify in our submission what it is that the risk, what type of tort is the risk of it occurring is enhanced by his appointment. In a sense.
Yes, in a sense, which is why that initial question,
yeah,
as at stage 1, seems quite difficult.
Yes.
Because you're now, well, it seems to me you're relying on that sort of idea to make stage 2 intelligible.
Yes. In a sense, stage 2 is the control mechanism which prevents that from broadening the potential liability too much.
certainly at some stage it would help me to have a list of all those activities that you say were assigned to Mr. Sewell as an elder.
Yes.
And you've taken us to the primary responsibilities, which are set out in the affidavit, I think at page 389. And you've taken us to the Court of Appeals summary of them. But I would like to know exactly what you say are the activities and roles assigned to him.
Well, I'm very conscious that your Lordship needs my help with that, and perhaps that's something we could consider overnight, because, as your Lordship has said, it's principally, perhaps exclusively, a stage 2 issue.
Yeah.
Just and equally, you know, you've been referring to the Jehovah's Witnesses organisation throughout your submissions. Perhaps overnight you could think about how to focus on why the members of the congregation are to be regarded as employers.
Yes, I'm afraid at the moment I've got no clear answer about that at all, other than a very vague recollection in the distant past when this case began that there was a certain amount of correspondence about that, but we will do that. And the trouble is I might be confusing it with the earlier case as well.
It seems to be a case where, because the United States indemnity came in, parties may not have focused particularly on the role of the congregation in relation to the control of the elder.
That may be right, although I think the concession that the United States would indemnify came much later, actually. But I think that was quite a bit later. But we will check and go back and
no, it's just on my part, the fact that the congregation don't appoint the elder and don't remove the elder does call into question the degree of control the congregation have over the elder.
Yeah. It rather seems as though they're simply notified by the branch that somebody has been appointed.
As I understand it, the process is instigated by the elders in the local congregation, and it then goes up and comes back down again, I suspect.
But what comes down is an appointment, not an instruction or an approval to an appointment.
Well, can I come back to that?
But you're accepting that they're going to be, I mean, you've given the examples of assault and theft. I mean, if I was to say to you, here's this elder carrying out his window cleaning business, and he happens to injure somebody while he's doing that, I assume you're not suggesting that the elders, that the congregation could be vicariously liable for that. Now, why not, if what you're telling us is that every aspect of life is controlled by the Jehovah's Witness?
Well, it's one of the factors but that wouldn't be determinative in that situation in a submission.
And it would be predominantly because there's no sufficiently close connection? Yeah.
It would be the stage 2 control.
Yeah.
Thank you.
So we would say, just dealing with control, everything we would say, including the activity of the elders, is controlled from above. The relationship we would submit is, and the manner in which that control takes place, is at least akin to an employee-employer relationship. In fact, we would say it's a much closer relationship, given the all-pervasive aspect of the control over an elder's life, just as has been observed, other members of the congregation. It couldn't be further from the kind of employment where an employee can down tools and go home at 5 p.m. or whenever it would be. And the elders take the lead at congregational meetings, but the discussion of topics is usually determined from above, the Watchtower articles and so forth, to which I've referred. And moving on then to the third signpost, organisation, the organisation is highly structured and hierarchical, and the role of an elder, itself being defined by the organisation's interpretation of Scripture, is central to it. Its structure is set out, is described by Mr. Schofield in his statement at paragraphs 12 to 16 at page 382, just summarising that, if I may, from governing body in New York to branch office in London to district circuits, congregations, and then even to the smaller local groups of Bible studies. Each is supervised by elders, by overseers, elders, and ministerial servants. There's a very large quantity of highly prescriptive guidance and literature as to how a ministerial servant and an elder should serve, act, and behave, and how publishers should adhere to that guidance. Ultimately, the elder and the organisation serve the same common purpose of spreading the word of God. And just comparing that, if I may, with Lord Justice Ward's in Lord Justice Ward's analysis in that case at paragraph 77, if your lordships would turn to page 574, he says that in the second part of that paragraph, he says, translating that into secular language, there's an organisation called the Roman Catholic Church with the Pope in the head office, with its regional offices, with their appointed bishops and with local branches, the parishes with their appointed priests. This looks like a business and operates like a business. Its objective is to spread the word of God. The priest has a central role in meeting that target. Ministering as he does to the souls of the faithful can be seen to be the very lifeblood of the church, vital to its existence. And one could, in my submission, transpose Jehovah's Witness organisation to the Roman Catholic Church in that passage, an elder for the word priest, and one would have a similar situation to that. In terms of organisation, the elder is absolutely central. And then the next penultimate test is entrepreneur. Last test, I'm sorry, the fifth test. The elders cannot, we submit, in any sensible way, be said to be acting as independent contractors in the sense that an elder could be said to be in business on his own account. The role depends on appointment and then on adherence to the requirements of the organisation. As he could, if he were an independent contractor, he can't go and offer his services elsewhere to another religion or organisation. Indeed, if an elder is removed or excommunicated, disfellowshipped, he's removed from the congregation altogether and can no longer take part in the organisation at all, hardly with respect to the fate of an independent contractor if he loses a particular piece of work. Posing Baroness Hale's question in paragraph 27 of the Barclays Bank case, is the tortfeasor carrying on business on his own account? In no way can it be sensibly suggested that in performing the activities of an elder, leading the congregation to spread the word, acting with other elders as the chief conduit to disseminate teachings to the congregation, providing pastoral support, was he carrying on business on his own account? This is, we would submit, not a doubtful case. And on stage one, if that's right, we would say that is the end of the matter. I come back, if I may, conscious that of the discussion of your lordship's points on risk and the extent to which it impinges on stage one. But can I come back to risk just now? The essence, in my submission, of the stage one test is that which your lordship, Lord Reid, set out in Cox. It's a relationship other than one of employment is in principle capable. This is, I'm sorry, paragraph 24 on page 498, the one that I've taken you to already, at the top of the page. a relationship other than one of employment is in principle capable of giving rise to vicarious liability, where harm is wrongfully done by an individual who carries on activities as an integral part of the business activities carried on by a defendant and for its benefit, and where the commission of the wrongful act is a risk created by the defendant by assigning those activities to the individual in question. And
that summary, I think, was the basis on which the judge got the 2 questions for stage 1.
Yeah.
But that summary isn't discussing stage 1. It's discussing Lord Philip's overall approach, as I understand it, to vicarious liability, having examined the 5 purposes immediately before that. I don't see how this passage can be taken as a basis for a 2-question stage 1.
Well, of course, the case of Barclays Bank was a stage 1 case. Your Lordship was dealing with stage 1.
But we're looking at Cox here, yes.
In Cox, yes. Can I just take you right back to the Canadian cases just briefly? First of all, the Basley's case. Basley's case, unfortunately, is not in your bundle, but there's a very helpful reference to the passage which I rely upon in Marga at page 673. As I say, I'm going to come back to Marga, if I may, at stage 2. At paragraph 86, Lord Justice Longmore says, in Basley's case, the court imposed liability on the operators of a residential care facility for emotionally troubled children. The employees had quasi-parental duties ranging from general supervision to more intimate duties, such as bathing the children and putting them to bed. But Justice McLaughlin surveyed the law of vicarious liability and summarised her conclusions in paragraph 46. In summary, she said, the test for vicarious liability for an employee's sexual abuse of a child should focus on whether the employer's enterprise and empowerment of the employee materially increase the risk of the sexual assault and hence the harm. The test must not be applied mechanically, but with a sensitive view to the policy considerations that justify the imposition of vicarious liability, fair and efficient compensation for wrong and deterrence. This requires trial judges to investigate the employee's specific duties and determine whether they gave rise to special opportunities for wrongdoing. Because of the peculiar exercise of power and trust that pervade cases such as child abuse, special attention should be paid to the existence of a power or dependency relationship, which on its own often creates a considerable risk of wrongdoing. In my submission, both the trial judge and the Court of Appeal carefully considered all of the authorities and correctly applied the legal test. The trial judge placed emphasis on the fact that the power afforded to elders required publishers, such as the Respondent, to be obedient and submissive to them, provided, of course, always that they were not required to act contrary to the Scriptures, although the Lordships will have in mind that passage in the Watchtower as to the extent to which they should follow the directions of the elders. Applying the reasoning of Lord Justice Longmore in Marga, the imposition of power to the elders by the appellants creates the risk that they will abuse it. And that approach would be consistent with the approach adopted by the Court of Appeal by Lord Justice Stuart Smith in the Blackpool Football Club case. Can I take your Lordship to a passage in his Lordship's judgment, to which you won't take at page 468. Where he says this at paragraph 102, this is page 468. Lordship says, questions of vicarious liability will generally not arise unless the tortfeasor can be described as doing something for or for the benefit of the employer or their enterprise. That will therefore seldom be a determinative characteristic. More is required, both at stage 1 and stage 2, than that the employer has engaged the tortfeasor to carry out work which gave them the opportunity to commit the tortious acts in question. To my mind, the authorities suggest that it is the combination of the creation of enterprise risk inherent in the employer's business, combined with the measure of control, if only in assigning the tortfeasor to roles that significantly enhance that risk, that will frequently provide the touchstone for the synthesis of stage 1 and stage 2. That of itself necessitates a close examination of the relationship between the tortfeasor and the person on whom vicarious liability may be imposed, both when addressing whether their relationship is one which is capable of giving rise to vicarious liability, and when considering whether the connection that links that relationship, the relationship between D1 and D2, and the tortious act or omission of D1, is sufficient to justify the imposition of vicarious liability on the facts of the particular case. So again, in that case, His Lordship is recognising the importance of enterprise risk, as he describes it, as one of the factors, crucial factor, along with the measure of control.
If I take you back to page 498, paragraph 24, which is Lord Reed's test, I didn't understand that as to be anything different from akin to employment test. And I didn't understand that to be any different from akin to employment and or analogous to employment. And I think that's what Lady Hale is saying at page 439, paragraph 22. So the two tests are the same, in effect. And the akin to employment or analogous to employment test, I don't believe has anything to do with the creation of risk. We're looking solely at the relationship between the employer, the alleged employer, and the employee.
Yes, well, certainly that's the case in Lady Hale's judgment in Barclays Bank, except that, of course, is a slightly different case, but yes.
But Barclays is perhaps helpful as giving guidance as to the correct approach. In very short summary, as I understand it, what Lady Hale was saying was that in previous cases the courts have been paying too much attention to Lord Phillips's 5 policy factors.
Yes.
We need to focus on the facts of the relationship and decide whether it is truly akin to employment. And the policy factors she relegates to something which you might have regard in a doubtful case.
Doubtful cases, yes. Mm-hmm. Yes.
And I think one then has to look at Cox and the Christian Brethren case before it with that in mind. You know, that the whole idea of Barclays was to give clearer guidance because it was apparent that courts were struggling to apply what had been said in the earlier cases correctly.
Yes. We would submit that the judge was entitled to and was right to conclude that in this case the relationship between elders and the Jehovah's Witnesses organisation was one which was capable of giving rise to vicarious liability. And again, coming back to Lady Hale in Barclays, can it really be said that the tortfeasor, Mr. Sewell, as an elder, was carrying on business on his own account? Plainly not, nor with respect, as it's suggested by my learned friend, that he was. And this is not a doubtful case, as the trial judge's findings make clear. The elders are plainly integral to the organisation, and the nature of their role is directly controlled by the organisation. They are conferred with power by that organisation, and that power can be removed. For all of those reasons, in my submission, even leaving aside the difficult issue about risk, stage 1 was properly made out in this case.
And what do you say about the Blackpool Football Club case? Do you just say, well, distinguishable on its facts?
Yeah.
And what particularly about those facts make it different from this?
Well,
or is that too difficult to summarise very quickly?
And too painful. I've referred you to the passage in Lord Justice Stuart Smith's judgment, and that was the key passage with respect, which the respondent in that case failed to get over.
Right. You were counsel?
I was.
Yes. Right.
My Lords, I'm going to move on to stage 2, if I may, if there's anything else that I should say on stage 1. As the appellant sets out in its written case, the imposition of vicarious liability in sexual abuse cases has developed in an incremental but nevertheless principled manner. And a tension arises, we would say, in sexual abuse cases where, on the one hand, every act of sexual abuse, heinous as it always will be, will inevitably fall outside that which would be authorised by a defendant. But on the other, a defendant often, not necessarily, but often through its conferral of authority on the tortfeasor, has created the risk of abuse. And as I've said already, stage 2 can be viewed as a control mechanism for the imposition of vicarious liability. Stage 1 on its own, and we've seen some examples, would perhaps impose too onerous a burden upon potential defendants. And so the close connection test has been developed carefully, incrementally by the court, so as to ensure that vicarious liability is only imposed on a defendant where there is a genuinely close connection between the stage 1 relationship and the tort. It's our submission that the close connection test, i.e. whether there was a sufficiently close connection between the tort and what the employee was authorised to do, is a fair and reasonable test to apply in all cases of sexual abuse, just as it is in all cases where this issue arises. It's good law and has been applied consistently since Lister and should remain the test. Whilst the law may be slightly more nuanced in sexual abuse cases, given the obvious tension to which I referred that arises when considering that test in these cases, it's the same test being applied, we would submit. And applying different tests, depending, for example, on the individual characteristics of the survivor of the sexual abuse, if that is what's being suggested, and there's an interesting, but now I think academic section in both of our cases on the potential absurdity of trying to apply different tests for child sexual abuse cases from adult ones, which now no longer applies because that's not being pursued, we would submit be unprincipled and result in obvious unfairness in individual cases. And we would submit that the close connection test in this case was applied appropriately by both the trial judge and the Court of Appeal. First, enunciated, of course, in the Lister case, vicarious liability can be established in circumstances where the tortfeasor commits a criminal act and steps outside what the tortfeasor's employer, in inverted commas, has permitted him or her to do, just as an employer may be vicariously liable for deliberate and criminal act on the part of his employee, so he may be vicariously liable for acts of the employee which he has expressly forbidden him to do. Those are the words of Lord Millett at paragraph 77 in the Lister case. The court, in overturning the traditional view articulated in Trotman, recognised the inherent unfairness in failing to impose vicarious liability for the sole reason that the tortfeasor had stepped outside the scope of his or her employment, or that which the tortfeasor was authorised to do. And at paragraph 24, Lord Steyne explained the need for the close connection test in this way. Would your lordships go, I think, back to page 599 in the judgment at paragraph 24, where he's dealing with Trotman, I think. And then he says, his lordship says in the second part of that paragraph, if I correctly understand this passage, it appears to be indicating that there could not be vicarious liability by an employer for a brutal assault or serious sexual misconduct, whatever the circumstances. That appears to be a case of saying the greater the fault of the servant, the less the liability of the master. A better approach, his lordship says, is to concentrate on the relative closeness of the connection between the nature of the employment and the particular tort. And the appellant rightly points out that when Lister was decided, the House of Lords saw, to use Lord Clyde's words, no reason for putting sexual abuse cases into a special category of their own. That's paragraph 48 of his judgment. Since then, the common law has developed. In the Christian Brothers case, Lord Phillips noted, as you've been taken to the passage, that the precise criteria for imposing vicarious liability for sexual abuse are still in the course of refinement for judicial decision. Now, that was 11 years after Lister. But the important points to note at this stage are that the close connection test remains the correct test to apply at stage 2. Its genesis lying in the very policy reasons which caused the court to apply the test in the first place in Lister. And in the subsequent authorities, the appellate courts have recognised the importance of preserving that test, the close connection test, in sexual abuse cases. And there should be no distinction nor any different application of the close connection test. As the appellant rightly says, the test should be applied to all cases of vicarious liability, and there should not be a separate test of vicarious liability for cases of sexual abuse. It was affirmed by this court in the Christian Brothers case. That case was dealing with acts of abuse against children, but the policy considerations behind the test must apply to cases of sexual abuse more generally. At page 739 in your bundle.
So am I to understand, but both parties are saying there's no different law applicable to sexual abuse cases as far as vicarious liability is concerned. So what's meant by tailoring?
Well, I'm coming to
your submission. Sorry.
We do say that the position is more nuanced in sexual abuse cases, but I'll come to that if I may. I take you to Lord Phillips at page 739, where at paragraph 83, the second sentence, he says, in the Lister case, Lord Clyde said that cases of sexual abuse by an employee should be approached in the same way as other cases in the context of vicarious liability. Nonetheless, the courts have been tailoring this area of the law by emphasising the importance of criteria that are particularly relevant to this form of wrong. In this way, the courts have succeeded in developing the law of vicarious liability so as to ensure that a remedy for the harm caused by abuse is provided by those that should fairly bear that liability. And then at 84, picking it up in the second sentence, what has weighed with the courts has been the fact that the relationship has facilitated the commission of the abuse by placing the abusers in a position where they enjoy both physical proximity to their victims and the influence of authority over them, both as teachers and as men of God. And then at 86, finally, starting with the Canadian authorities, that's Basley and Jacobi, the decisions of Justice McLaughlin, a common theme can be traced through most of the cases to which I've referred. Vicarious liability is imposed where a defendant whose relationship with the abuser put it in a position to use the abuser to carry on its business or to further its own interests has done so in a manner which has created or significantly enhanced the risk that the victim or victims would suffer the relevant abuse. The essential closeness of connection between the relationship between the defendant and tortfeasor and the acts of abuse thus involves a strong causative link. The most important point we would say is that, as is made clear in the second Morrison's case, the close connection test is preserved, as your Lordship, my Lord Reid, made clear in those passages in Morrison's. Your Lordship specifically recognised that in cases such as sexual abuse cases, child sexual abuse cases, in that was the specific example given, the close connection has been applied differently. Can I just remind your Lordships of what my Lord Reid said in that case at page 759. Paragraph 23. In that passage, Lord Nichols identified the general principle, the best general answer, as he said, applicable to vicarious liability arising out of a relationship of employment. The wrongful conduct must be closely connected with acts the employee was authorised to do for the purposes of the liability of the employer to third parties. It may fairly and properly be regarded as done by the employee while acting in the course of his employment. As Lord Phillips noted in the Catholic Child Welfare Society case, the Christian Brothers case, the close connection test has been applied differently in cases concerned with the sexual abuse of children, which cannot be regarded as something done by the employee while acting in the ordinary course of his employment. Instead, the courts have emphasised the importance of criteria that are particularly relevant to that form of wrongdoing, such as the employer's control or authority on the employee over the victims which he has abused. In this case, in the Court of Appeal, the need for the close connection test was aptly summarised by Lord Justice Mayle at paragraph 92. So this is page 139, if I may. Paragraph 92, his Lordship says, as the Supreme Court has confirmed in the Morrison Supermarket, the various claimants in Morrison Supermarket case. The second stage is concerned with whether the wrongful act is so closely connected with the acts which the employee was authorised to do that for the purposes of the liability of the employer to third parties, it may fairly and properly be regarded as done by the employee while acting in the ordinary course of his employment. That general test requires adaptation in cases of sexual abuse, because sexual abuse cannot be regarded as something done while acting in the ordinary course of a person's employment. And then,
if I may say so, what I said in the passage that's being quoted is that the test had been applied differently. I didn't say it was a different test.
no, and I don't submit it's a different test.
The test is one of close connection to the acts which the employee is authorised to do. And if you're thinking about sexual abuse of children in the sort of settings where it normally, outside the home, if you're talking about vicarious liability, sort of institutions where it occurs, the employee will be authorised to exercise, or typically, if he's not, there may not be vicarious liability, but typically he'll be somebody authorised to exercise authority over children. He may have disciplinary powers. He may be someone who puts them to bed. He may be someone who gives them a bath. The connection between the abuse and what he is authorised to do may be very clear, but obviously there wouldn't be an analogy in the case, or not a close analogy to that in the case of an adult, unless you're dealing with perhaps the very vulnerable, elderly people or the disabled.
Well, I suppose each case is different, but I entirely take your Lordship's point that it is a question of applying it differently rather than it being a different test. I completely agree.
Yes, my attention has been drawn to the time.
Yes. Well, I'm quite content to break off.
If that's I think it might be a convenient.
Yes.
We'll resume at 10:30 tomorrow morning.